participants. At this point, please go ahead and introduce yourselves to us in the chat by sharing your name, preferred pronouns, where you're calling in from, and whether your group is perhaps considering redistricting litigation in your area. Today's training is convened by Charge. Charge is the coalition hub advancing redistricting and grassroots engagement. It is a coalition of 9 organizations with national reach, united around a common goal that redistricting must be transformed to allow more voices to participate, be heard, and ultimately be represented. On this specific training today, we are joined by expert litigators from Asian Americans Advancing Justice AAJC, the Mexican American Legal Defense and Education Fund, the Southern Coalition for Social Justice, and State Voices. We hope that this training will provide you with a better picture of how organizers can set the stage for litigation in your various states. Next slide, please. So here's our agenda for today. We're going to hear a comprehensive overview from Thomas Sayens, President and General Counsel of MALDEF, on redistricting in 2021. Next up, we're going to hear from Allison Riggs, Co-Executive Director and Chief Counsel for Voting Rights, and Mitchell Brown, Equal Justice Works Fellow, both at the Southern Coalition for Social Justice, as they lay out the things you need to know in order to build a record for litigation. Then we're going to welcome Terry Minnis, Senior Director of Census and Voting Programs at Advancing Justice AAJC, for a look into the current federal landscape. And during the entirety of today's training, please go ahead and use the chat to ask any questions that you have. We're going to get to them during the Q&A portion towards the end of the training. And finally, Lata Knott, Deputy Director of Policy at State Voices, will provide you all with some helpful resources as you move forward in your litigation journeys. Next slide, please. So, a couple of things to get out of the way. Let me start first by saying that I am not an attorney myself, though we are joined by several fantastic ones today. Given the fact that we're going to be covering some legal issues today, we just wanted to provide you with a quick standard legal disclaimer. This training is intended for educational and informational purposes only. Nothing provided in the course of this training creates or constitutes an attorney-client relationship, nor is it intended to convey or constitute legal advice. As I mentioned, I'm not an attorney, I'm an organizer. And I know from my own personal experience that there's a natural intersection between organizing and litigation. In fact, some of the best attorneys that I know are organizers in their own way, and some were organizers first. I spent the majority of my life as an undocumented Filipino American. In the state of Georgia, where I live, the university system bans undocumented students from its top colleges and universities, restricting access to higher education. When I was in college, I and some of my friends sought to challenge these policies through litigation in the state court system. So we secured pro bono counsel and set out to organize, recruit other plaintiffs, and educate the general public about our efforts. While we ultimately lost that litigation in the Georgia Supreme Court, it drew a ton of attention to the plight of college aspiring undocumented students. So you can see the relationship there. So specifically, the task at hand before us is litigation during the redistricting process. The Voting Rights Act of 1965 provides us with a number of opportunities to seek judicial relief. That means asking a court to intervene if provisions of the law are violated during the redistricting process. Our presenters today will cover these opportunities later, but I want to emphasize that the VRA is under attack. And this is why we need federal protections for voting and sharper tools in our litigation toolboxes. So for this reason, we support the passage of the For the People Act and the John Lewis Voting Rights Advancement Act in Congress, and we call on our elected representatives to act now. Next slide, please. And with that said, I'm going to go ahead and pass it on to my colleague, Thomas, to tell us about redistricting in 2021.
Thank you, Raymond. Hello, everyone. So it's my task to give a brief background of the kind of litigation that may be involved in redistricting, to permit my colleagues to talk more about what you do when you're organizing and advocacy around redistricting to prepare for the potential process of litigation. So the 3 kinds of claims that I'm going to talk about, I will first talk about malapportionment. I will then talk about vote dilution. And finally, I'll talk briefly about racial gerrymandering. Now, only one of these stems from the Voting Rights Act, namely vote dilution, but often racial gerrymandering and malapportionment may also go along with litigation under the VRA or otherwise related to redistricting. In fact, you could have a single case that involves all three kinds of claims: malapportionment, vote dilution, and redistricting. Or you could have cases that involve only two. Let me talk about them briefly. For many of you, I know this is review, and I apologize for the repetition. But let me begin with what is called malapportionment. This basically comes from what requires every jurisdiction to engage in redistricting in the first place. And that is a series of cases in the 1960s decided by the US Supreme Court and establishing what has come to be called the one person, one vote principle. This litigation came out of the fact that prior to the 1960s, many states and other jurisdictions did not engage in redistricting, with the result that a number of districts in the same body had dramatically different populations as a result of the growth in population in some areas, larger growth, faster growth in comparison to others. What the Supreme Court decided was that allowing these kinds of dramatic disparities in population between districts in the same body was a violation of the 14th Amendment and a violation of what they came to call the one person, one vote principle. It's grounded in a notion that every constituent should have the same opportunity to influence their elected official. And that can't happen if you have dramatic disparities in size, population size of districts. This then triggered the responsibility every decade to redraw district lines to make them relatively equal in population. Where a jurisdiction fails to draw districts that are roughly equal in population, and I'll talk about that, that creates a malapportionment violation. That violation, constitutional violation that can be the basis for challenging the lines that have been drawn, or in some cases not drawn. I say that last point because often malapportionment cases stem from a jurisdiction failing to adopt new lines reflecting new populations as reported by the US Census. That means that they're effectively leaving in place outdated lines from the previous decade, despite relative differences in population change, meaning that districts are now dramatically disparate in their population. Malapportionment cases, if they challenge statewide redistricting, do end up before 3-judge district courts. That is to say, you not only have one judge, but 3 deciding your case before a trial court. That case would then be appealed directly to the US Supreme Court, bypassing the Court of Appeals. This is a peculiar characteristic, particularly of redistricting litigation in this day and age. It includes malapportionment violation cases. Malapportionment can occur not only if a jurisdiction fails to redraw the lines and leaves in place the lines from the prior decade, but also can occur even when they have engaged in redistricting, but have dramatic disparities in population between districts in the same body. When it comes to Congress, the US Supreme Court has traditionally held that congressional districts within a state must be as equal as possible. That literally means that a congressional district in the same state as another can only differ from that other district by one person in population. So they mean as equal as possible when it comes to congressional districts. When it comes to state legislative and other local legislative districts, there is more leeway. Traditionally, there has been a 10% rule. It's not a hard and fast rule. There may be circumstances where a greater than 10% deviation is allowed, and there may be circumstances where a 10% deviation is too much. But the point is, you have to have districts that are relatively close in population, but not absolutely equal in population, outside of the congressional context. By the way, a 10% deviation means the largest district population in a state senate or state house, for example, and the smallest district, in state house, must be within 10% of each other in population. It's important to note that malapportionment, as redistricting itself, has everywhere in the country been based on total population numbers reported by the decennial census. Now, it's important to make this point because there are forces still working in the country who want to use a different population base, namely potential voter population, to equalize districts. You can imagine what the effect of doing that would be. Its effects would be devastating on minority communities because we both have larger proportions of the population that are not yet citizens, therefore are not yet potential voters. And we have larger proportions of our populations that are under 18. And using voter population as a basis for equalizing districts discounts anyone under the age of 18 at the time the census is conducted. We don't expect it this year. There may be attempts to use something other than total population, voter population, to redraw districts in some jurisdictions across the country. The reason we don't expect it is that the data needed to engage in that kind of equalization is not going to be provided at block level by the Census Bureau. Namely, citizenship data is not provided with decennial census data and is therefore not available at the block level. Now, another circumstance where malapportionment may come up, and we're already seeing this, is where a jurisdiction chooses to use something other than decennial census data to redraw its lines. Many of you may be aware that the state of Illinois, in order to meet a state constitutional deadline to adopt new maps by the end of June, used ACS, or American Community Survey, estimate data from the Census Bureau to redraw its lines this year. As a result, Illinois is currently in litigation, including litigation brought by Maldiv on behalf of Latino voters, challenging the use of ACS data to draw district lines as a malapportionment violation. The main reason behind that is that ACS is, as I said, an estimate based on a sample of the population conducted every year. But it also means that because it's sample data, the Bureau combines the samples over succeeding years, so that the data created today is actually for the last 5 years. Therefore, it is not as up to date as decennial census data, which collects information on the population as of April 1st, 2020. That's the basis for that potential malapportionment violation. Let me now turn to vote dilution. Next slide. Yeah, we go. So vote dilution is the main claim related to redistricting under the Voting Rights Act of 1965. There is a duty for redistrictors to draw minority opportunity districts under the Voting Rights Act where certain conditions are met. The test in litigation under the Voting Rights Act for vote dilution in redistricting is called a totality of the circumstances test. You can tell from the name that cases that can be very involved, including lots of expert testimony, lay witness testimony, and documentary evidence. But the prerequisite for any vote dilution claim is clearly established by the Supreme Court in a case from the 1980s. In that case, the Supreme Court established certain prerequisites for a vote dilution claim. First, you must be able to draw a compact majority-minority district. What that means is, if your population of the minority group you are representing is too small to create a majority, and in this case, it's usually either a voting age population majority or a citizen voting age population majority. In other words, a majority of those likely to vote and participate in an election. So if your population is too small in a state or other jurisdiction to create the majority of the district, you would not be able to bring a vote dilution claim. Similarly, if your population is large enough to comprise a majority, voting age or citizen voting age majority of a district, but is too spread out throughout a state or jurisdiction that you cannot draw a compact district, you would also be prevented from moving forward from a vote dilution claim. But where you can draw a compact district that is majority Latino, for example, or a majority Black or majority API, then you have met the first prerequisite for a vote dilution. The second and third prerequisites, which I'm going to combine into one, basically constitute racially polarized voting. And what that means, one of these preconditions is that the minority group you represent is voting cohesively. Doesn't mean 100%, doesn't mean 90%, but it means that consistently, election after election, that minority group of voters is voting cohesively in favor of the same candidate or on the same issue. The other half of racially polarized voting, the third precondition under the Supreme Court's model, is that the white community is outvoting minority community. It has different views about the candidate to be elected or about an issue on the ballot, and where it is the majority outvotes the minority group, with the result that the minority group does not have an opportunity to elect candidates of choice unless it has a majority minority district. So racially polarized voting means that whites are consistently, not 100% of the time, but consistently outvoting minority groups voters, and the minority group is prevented from electing a candidate of choice. Important to note here, when it comes to vote dilution, you are looking both at census population data, including voting age population provided by the Census Bureau for the decennial census in its redistricting data release, and you are often looking at ACS estimates of citizenship to determine if you have a age population majority in a potential. If you have those preconditions, ability to draw a compact majority minority district, and racially polarized voting, then a vote dilution claim will involve consideration of a number of different factors, many of them called the Senate factors. There's things like a history of discrimination, the use of racial appeals in voting, how polarized voting is in the jurisdiction, whether the body that you're challenging has shown a record of not being responsive to concerns of the minority community. It's a non-exhaustive list of factors that suggest that there is some discrimination going on when it comes to voting and in policymaking, such that a vote dilution claim should succeed under the totality of the circumstances. My colleagues in a moment will tell you more. As I conclude, I want to talk about the third potential claim related to redistricting. This is also a constitutional claim, not in the Voting Rights Act, but in the Constitution as interpreted by the Supreme Court beginning in the 1990s. This is a racial gerrymandering claim, or a claim that the redistrictors unduly considered race in drawing lines. Now, it's important to note that the Supreme Court has acknowledged and recognized that race must be considered in the course of engaging in redistricting, in part in order to ensure that redistrictors are complying with the Voting Rights Act and its mandate to prevent vote dilution, as I described. So consideration of race is legitimate, but it cannot be allowed to predominate, to be the main consideration, according to the Supreme Court, and it cannot outweigh traditional redistricting principles unless it is being considered solely to comply with the Voting Rights Act and its prohibition on vote dilution. Now, when racial gerrymandering first was developed by the Supreme Court in the 90s, it was thought by many, including judges, to apply only to white voters challenging minority districts. Fortunately, in the meantime, the Supreme Court has made clear that it is a claim available to any group to challenge the undue consideration of race. So we now have civil rights cases that challenge district drawing as racial gerrymandering, particularly where a redistrictor may have concentrated or packed too many minority voters into a particular district when it was unnecessary to do so, and doing so violated traditional redistricting principles, mainly related to keeping communities of interest intact. So these three kinds of claims, malapportionment, vote dilution, and racial gerrymandering, are the backdrop for litigation related to the redistricting process. They will be the core of any case filed by you or with you challenging redistrictors in your jurisdiction. I'm now turning it over to my colleagues who will tell you more about what you should be thinking about as you anticipate the possibility of needing to file litigation under one of these claims to challenge unfair redistricting in your jurisdiction. Thanks.
Thank you, Tom. Thank you all for participating today and for having us here. I want to talk briefly about some of the things to keep an eye out for and a couple of case studies where we've seen community introduced evidence be really powerful in our experience. Joining me today, so you don't have to listen to me talk too much, is my colleague Mitchell Brown. And before we dive in, I want to be frank and address something that folks might be worried about. Terry Alminis will talk about this more in the federal landscape, but the concern that the federal judiciary may have it out for Section 2 in voting rights cases, really redistricting cases coming up. This is a real concern, but one, we have always tried to be strategic in bringing litigation under the Voting Rights Act, and really in any case, advancing the interests and rights of voters of color, because we have faced such hostility in the federal courts. So that is not new, but it is one of the reasons why we need to focus so much on building better records. And to the extent we do need to be strategic in our litigation, the same thing is true now as has been in history, that relief for systemic oppression won't always be found in the courthouse. And so organizing and advocating, building momentum and shifting narratives will always be important. So next slide. There are things, we don't have the redistricting data yet. As Thomas mentioned, there are some jurisdictions that have already started redistricting using data that is less than ideal. But for folks that in jurisdictions where redistricting has not begun, there are things that you can do right now to get ready. And the time is running short for when that get ready part is, that with the expected release of the census data by August 16th. But get the shape files for existing district lines. Shape files are map boundaries that you can import into free online services, or if you use a commercial software, get them now. We get them from the Redistricting Data Hub. We want to understand and be ready to take what we currently have, and understanding where it's not serving voters of color very well. Take what we have right now, understand where we think population change is going to be, and start being strategic going forward. Learn from community expertise. Talk to folks, particularly when you're engaging in local redistricting. Understand what candidates of choice of voters of color have run and not been successful. Where they have run, try to understand what's been key to that success. Understanding that what doesn't work about current districts can help us better advocate for what districts that will work better for the communities we represent. Think critically about population changes where there's been growth and loss of population. All too often, those seated at the table of white supremacy, hanging on to power, desperately trying to hang on to power in light of changing demographics, want to pit groups against each other rather than cede their share of power and representation. And so we need to name that, acknowledge that, and start thinking about how relative population changes amongst our constituencies may impact how we draw district lines. And just wanted to make clear that the data that's coming out from the Census Bureau by August 16th is totally usable. We don't have to wait for the quote unquote user-friendly drop in September. The data redistricting data hub will be processing that data, and it will be usable as well. Many states will also be doing that. Next slide. Here's some things to sort of keep an eye out for when you're looking at your jurisdiction, town council, water district, school board, you name it, some things to look for. These are not things that are always per se bad, but they're things to just examine. Look for split precincts or voter tabulation districts. Again, this is not per se problematic. Sometimes we have to split precincts to achieve population equality. That's a good thing. Sometimes we have to split precincts to create new opportunity districts for voters of color, a good thing. But we've also seen precinct splitting used for nefarious purposes. So when you see an excessive number of split precincts, or even just a lot, particularly compared to that previous map, ask why. Look for irregularly shaped non-compact districts. Again, it's not a per se problem, it's a ask more questions kind of flag. Some of the districts that many of our organizations have advocated for to comply with Section 2 of the Voting Rights Act, we've heard complaints that they are non-compact or not pretty shaped. Pretty is in the eye of the beholder, and obviously we care about the representation that districts create, but again, it's a tool that can be used for improper purposes. Look for demographic percentages that are far above what's required to elect a candidate of choice. So packing, if you had a district that was electing a Black representative or a representative preferred by Black voters at, say, 40% Black voting age population, and that district was drawn up to 55%, that should raise a flag. Look where representation does not reflect demographics of the jurisdiction. If your state got an extra congressional district, if your state is growing in population, and particularly AAPI population or Latinx population, make sure that the districts created or the districts are drawn reflect that. There's no guarantee of exactly proportional representation, but it's another flag and things to look at. Populations of districts can be overpopulated or underpopulated to disadvantage voters of color. Keep an eye out on that. If you see districts, majority Black districts consistently overpopulated and majority white districts consistently underpopulated, and by that I mean deviating from the ideal population, that can be a problem. Pairing incumbents, particularly pairing incumbents of color, incumbency protection is not central to any of our work, but it can be used to undermine representation for voters of color, where Black incumbents paired together. I worked on a case where Black incumbents were paired together to increase the likelihood of more white representatives being elected. So just to be cognizant of time, let's skip to the next slide. Drawing community maps. Many of you in the Charge Hub and beyond are drawing community maps, and that's a great thing. My sort of number one rule is do your very best to make sure that the maps submitted are legally compliant. That might mean reaching out to one of the groups that we'll mention at the end that litigates these things, but you can lose a lot of political power and capital by introducing maps or advocating for maps that don't comply with all of the applicable laws. So it's just a gut check before final submission. There are redistricting trade-offs. Be as inclusive as possible when you're drawing community maps to make sure that you have not created opportunities for one group at the expense of another if that's not necessary. Talk to each other about identifying communities of interest. That is the most powerful evidence, and I'll give you a specific example here shortly. It's the most powerful evidence when it's well coordinated, and ill-intentioned map drawers can't say, Group A said this was a community of interest, and Group B said this completely contradictory space was a community of interest, and so I can't use community of interest data at all. So that's the only way to get around that, is to organize and communicate in advance. Next slide. I want to talk about a couple of places where racial and ethnic coalition and communities of interest evidence has been really helpful. And one was in Lee County, Florida. The Lee County School Board had until 2018 never elected a representative of color, even though 55% of the children in the school district were children of color. And so the Lee County NAACP initiated a public advocacy campaign to get districts that would help voters of color elect their candidate of choice. Next slide. They had, prior to a 2014 referendum, at-large elections, they had residency districts. So the school board member running had to live in one of the districts, but everyone in the county, which is still majority white, barely, was voting on those candidates, and Latinx and Black candidates had run and been defeated. So the NAACP, after the referendum, and this is all work that they publicly presented to the school board and in the community, wanted to, after this referendum, to move from residency districts to single districts. The NAACP wanted to talk about communities of interest in ensuring that a coalition district could be created. Next slide. So these were the districts the NAACP proposed, and District 5 was a district that was majority Black and Latinx. And when presenting this map and arguing for it, they wanted to be prepared for folks that might be unfriendly to the idea of creating a coalition district. Next slide. So what they did was talk about keeping communities of interest intact. They talked not only about the district that they wanted to see drawn, District 5, they talked about all of the other districts too. So a map is always, there's a domino effect in a map. And so don't be overly focused on just the district that you want. Also talk about how it can advance communities of interest in other districts. District 5, which was the majority Black and Latinx district, combined parts of Fort Myers with Lehigh Acres. And the NAACP talked to the school board and the public generally about the migration patterns, the historic segregation patterns that Lee County, Florida had experienced that created a reasonably compact minority community in that area. They talked about ACS data. They talked about educational attainment, income levels, to explain why this district was in fact a district of a community of interest and good for the county. Next slide. I can't remember if I have so how did that end? The NAACP didn't exactly get its proposed map, but it did get a map where a district was drawn that enabled the county to elect its first African-American member to the school board. So it was somewhat similar to this, but understand that success doesn't always look like getting your exact map, but if you're influencing the map and getting line drawers to understand your communities and communities of interest, you can ultimately end up meeting your goal. Next slide. I want to talk to you about another district in Fort Bend County, Texas. Next slide. Fort Bend County is one of the most demographically diverse counties in the state of Texas. It had, after the 2010 census, 3.5 state house districts that were based out of Fort Bend County. And as you can see, white voters, Anglo voters were in the minority in the county, and there were substantial Black, Asian, AAPI, and Hispanic populations in the county as well. So when we were talking with folks in Fort Bend County, and given its incredible diversity, there was a lot of commitment to ensuring that all voters got a voice, and that districts in this county were not dominated by Anglo representation, given its diversity. Next slide. So how did we try to prove up coalition? I want to be clear, this was actually not a successful venture, but it doesn't mean that the evidence wasn't there, and it doesn't mean that this isn't something you can keep doing. What did the data show? We put on evidence of the diversity of candidates that ran and the consistency of voter preference across racial and ethnic groups. So on the election candidate list, you had African-American, Latinx, Asian, AAPI candidates, a whole number of racially diverse candidates going up against white candidates. And you saw a whole lot of coalition between those voters. So for example, one candidate, Ms. Wen, ran and received 84.1% of the African-American vote, only 9.8% of non-Hispanic white, 77.7% of the Latino vote, and 85.4% of the Asian vote. Our position is that shows a high level of coalition between Black, Latinx, and AAPI voters. But one of the things that the court wanted to see was they wanted to see racially contested elections and primaries, and that just wasn't happening in this district. There weren't busy Democratic primaries, let's say, where coalition could be tested there. So encouraging folks to run for office and putting together these kinds of racially polarized voting studies can really be incredibly helpful in proving up coalition. Next slide. The other thing you want to sort of be able to do, and this is using Maptitude, but can be done with any mapping tool publicly available, or in Texas's case, using Red Apple, but look at concentrations of different voters and see if district lines are splitting up what might be a naturally emerging coalition district. Here we saw AAPI voters being horribly cracked in order to prevent a naturally occurring coalition district that we believe would have elected the candidate of choice of AAPI voters. The green spot under Meadows Place was cut out of a Sugarland-based district, as was a few precincts right above that Thompson's label. So use the tools available to you now to talk about where voters live, housing patterns, and if district lines are undermining natural coalition building. With that, I'm going to hand over to my colleague Mitch now to talk about some process concerns that are also important for building a record for litigation.
Yes, so thank you, Allison, for that. And I'll be quick in the interest of time. I want to talk about process, but also before I talk about process, about finding plaintiffs. As we all know, we want to bring litigation along about these maps. We have to find plaintiffs. And one of my hopes is that as every organization is doing, its community outreach to different communities, that they're talking about possibly being a plaintiff in a case, and actually getting engaged in the redistricting process. There are different levels of interaction between the community and our organizations. We can hold educational events and tell them about it. We can have them do public comment. And then the ultimate form of engagement is actually being a plaintiff and challenging a gerrymandered district. It's important that you have plaintiffs that live in the districts that you're challenging, or else they won't have what's called standing in legal circle. They have to show injury, and they have to show that they live in that district. Or if you are trying to draw an opportunity district, so for example, in Louisiana, trying to draw another opportunity district for Black voters, you have to show somebody that would live in that newly created district in order to challenge it in court. And the bottom line is that just engage people and you start engaging them now and dropping, the hints that, hey, one day if we decide to challenge these maps, we're going to need your help on a very high level of being a plaintiff in a case. And the quote that I think about is something my grandfather used to say. He said, "Tell me and I forget, teach me and I may remember, but involve me and I learn." If we want our communities to really learn about this process, being a plaintiff is a great way to learn about the process because you are there in there. So start thinking about finding potential plaintiffs now. And then the second is about process. What the maps say once they are drawn is important, but how the maps are drawn and the process by which they're drawn is very, very important as well. And it's important that our groups come together in coalition. So litigators and data analysts and policy analysts, it's important that we develop talking points for community members to go to the legislatures or redistricting commissions or the school board, whoever redistricting, go and talk to them and have talking points created utilizing the resources and skills of our collective groups to give really, really specific public comment. I know it's one thing to say, I don't want my maps gerrymandered, but it's another thing to be very specific about communities of interest, or very specific about what you want to see in your maps. And so in order to prevent just surface level comments and have deeper level comments, it's important for all of us to utilize the resources that we have. And working together will give us the biggest return on investment of our resources. And also with process, we must push transparency. One of the things that we're pushing in North Carolina is that there is transparency both before the maps are created and also after the maps are created. And it's important, like the meetings before the maps are created are important because it helps in the creation of maps and solve some heartache down the line when the actual maps are created. So if we can talk about this is the community of interest that we want created, this is what we want in our maps before the maps are created, then that's a good thing. But also the meetings after the meetings for public comment after the maps are created is also more important. And it's important that we have multiple meetings in multiple different community groups and that those meetings are accessible, both for those who have disabilities, for those who are, COVID is still a thing. And so making sure that we have robust remote options for people to listen in to the meetings and are able to fully access those meetings both remotely or in person, and also are able to give comment either virtually or in person. And the bottom line is that the process for drawing maps and the opportunity for community input is very important, and we have to continue to push that. And with that, I'll turn it over to Terry.
Great, thank you so much, Mitchell. I'm just going to take a quick couple of minutes to talk about a couple of Supreme Court decisions that affect the Voting Rights Act and that implicate redistricting, and just quickly touch upon some federal legislation that could also potentially have some impact on this redistricting cycle. So the two primary provisions of the Voting Rights Act that apply to redistricting are Section 2 and Section 5, and Thomas gave a great rundown of what would be covered under Section 2, and Allison and Mitch kind of help walk through what that looks like and what you may want to be considering. So the other major provision, of course, is Section 5, and it was such a powerful tool. I mean, it technically still exists, and it is a powerful tool because it provides direct protection with its retrogression standard, that is not allowing for things such as redistricting plans to make minority population worse off. And indirectly, it was also a powerful tool, both because it provided notice to interested stakeholders such as all of us about the different things that are happening at different levels of government, but also so that is we would know about changes, voting changes that were made, not just at the state level, but also at the local level, where there could be particular, nefarious activity going on. Also, there was a prophylactic effect of Section 5, where jurisdictions that were covered, knowing that they would need to pre-clear all of their voting changes with the Department of Justice or a three-judge court at the DDC, that they would sort of act right, because they knew they would have to get approval from another entity. So again, right, that pre-clearance process was something that was very powerful. And again, in redistricting, that meant that all the redistricting plans of covered jurisdictions would have to be submitted and approved before they could go forward. In 2013, of course, the Supreme Court in their Shelby County v. Holder decision, while leaving intact the actual Section 5 pre-clearance process, invalidated the coverage formula, which meant even though Section 5 existed, it doesn't actually apply anywhere anymore. And as you all know, a lot of the Section 5 coverage were in southern states, counties in North Carolina, for example, Georgia and the like, as well as a couple of other places like counties in California. All of that, of course, is no longer here. We're about to enter our first redistricting cycle without a functioning Section 5. So we've lost a really effective tool in order to combat problematic redistricting plans. So while we are looking at the possibility of a lot more litigation needs within the redistricting context, we're facing the fact that there is a big loss or a big gap in our toolbox that we used to have. In the Brnovich decision, which Allison had referenced quickly, was just decided several weeks ago, I think the important thing to note is what the decision doesn't speak directly to a redistricting voting cases, right? It is within a vote denial context, but as Allison rightfully points out, I think both the Brnovich decision as well as the Shelby County v. Holder decision and many other things that we've seen out of the current Supreme Court does not necessarily bode well. So we do want to just keep an eye and be mindful of what we're doing and where that could lead. And then in 2 minutes, I will just slide two federal legislations that you should all be aware of that Raymond started us off with, right, is the John Lewis Voting Rights Advancement Act, which has not been introduced yet in this Congress, but should be introduced shortly. And the For the People Act, the John Lewis Voting Rights Advancement Act would address the Supreme Court decisions that I just mentioned by restoring and modernizing the Voting Rights Act. Just quickly, it would create a geographic trigger. It would also create a new complementary trigger based on demographics and known problematic practices that Advancing Justice AJC and MOLDEF have been working on extensively. And those that would certainly impact redistricting directly. And then For the People Act has a section that is dedicated to redistricting, including some major provisions such as requiring the use of independent redistricting commissions and creating a criteria that would set in stone sort of how all the congressional redistricting would have to abide by rules and prioritizations of what's most important, with, of course, as Thomas mentioned, the one person, one vote and the Voting Rights Act being, the top always. The last thing I'll just note is that even if these bills were to pass tomorrow, the impact on this redistricting cycle would be minimal, right? It's too late to put into play independent redistricting commissions for this redistricting cycle, even though that's what the For the People Act contemplates. But the criteria would be something that could be applicable to this redistricting cycle, which would, be helpful. And I think the Voting Rights Advancement Act, the John Lewis Voting Rights Advancement Act, even if passed tomorrow, unclear how quickly they'd be able to get, jurisdictions covered and whatnot. So they are important pieces of legislation. We should all be working towards, making sure that they are the best that they can be, and that, the best versions get passed. But just know that the immediate impact we would feel for this redistricting cycle would be somewhat minimized. And with that, I know we had some Q&A and we are running short on time, so I will turn this back over to you, Letta.
Thank you, Terry. We do have a few minutes for Q&A. A couple questions were already thrown in the chat, so I figure we'll start with those. Beth asked this, and this was during Allison and Mitchell's portion, but anybody who knows the answer, feel free to chime in. Which analysis tools would you recommend to measure, say, compactness?
So there are a bunch of different metrics, probably in excess of a dozen now. There are 3 that most commercially available software make the easiest to use. But I think from my perspective, there's no one metric that is superior. And I've seen people pick and choose them based on which one advances their cause. So I think looking at several may be helpful, but happy to hear from Tom and Terry on that as well.
The only thing that I would say is that, of course, those tools are available and should be used, particularly when you end up in litigation about compactness. But a lot of compactness can be done by looking at maps in comparison to what has been approved in the past. And oftentimes, I think you can tell if you've got a district that's going to be sufficiently compact versus one that is probably going to stretch the boundaries. If you're looking at one that you need to create that looks like it stretches the boundaries, I think that's when the tools that Allison has described become most useful, right? If you're going to have to justify something that on its face doesn't look as compact as other districts.
I don't have anything to add to the brilliance of my colleagues. So Letta, I think we have more questions, so we should just go ahead.
Awesome. And thank you for those answers. From Christopher, we have, what is the normal/expected range required to elect a representative of choice?
It's a intensely local appraisal. So it depends where you are, depends what participation levels are like in your specific area. There used to be a rule of thumb in the South to elect a candidate preferred by Black voters that you needed a 65% Black voting age population district. In many parts of the South, that's not true anymore, but there are still places. I think you'll see differences if you're talking about electing within a county versus electing statewide. Age and citizenship can play into that metric, but most of us, and certainly those of us who are litigating in court, are not going to tell you, that there's a one-size-fits-all number.
And I would just add to that the other things that can influence it is whether you have a primary election, a partisan primary, because if you can control the outcome in a partisan primary, which often can happen with less than 50% of the district, and that primary determines who wins a general election, that's a circumstance where sometimes you can elect candidates of choice with less than a majority. Important to point out that the test for litigation is still that you can create a majority district, but in practice, you may be able to create a minority opportunity district in circumstances like that with less than a majority. So it is, as Allison said, very much dependent on the circumstances, and you can evaluate what is effective by re-aggregating past elections, basically. You take the existing district, and if you have an election that's, say, statewide, and you know that your minority group supported one candidate, white supported another, you can look at that district and see who, if that were a district, who would have won in that district. So you can test effectiveness by looking at past elections.
Thank you. So we're at 1:59, almost at time. So I just want to take 1 second just to wrap things up and make sure everyone is aware of some available resources. So the slide, we're going to be sharing like the recording of the slide deck, these links in an email to all of you after this presentation. But just to walk you through what's available, we have contact information for the organizations, for many of the organizations that will be bringing redistricting litigation. And if you look at this list and you're not sure who to contact, and we have all the organizations that took part in this presentation today, as well as many others. But if you're not sure where to start, you're not sure who's litigating in your state, you can feel free to email me at lnot@statevoices.org, and I will point you in the right direction. Also a redistricting litigation tracker to see what other kinds of cases are being brought, and a link to the Charge Hub's website for other redistricting trainings. And thank you so much, everybody, for attending. Thank you so much to all of our presenters for sharing their knowledge with us. It's been wonderful to have you all here for an hour, and I hope this was useful to everybody. And good luck with all the work that you're doing.